I will focus my presentation on the PMAC, the Patent Mediation Arbitration Center, which, as Stefan already mentioned, opened its door on June 2nd. I was there in Ljubljana in my role as an arbitrator, and this disclaimer is necessary. This presentation only reflects my view and not the PMAC official view. I decided to draft 10 important questions, since I have 10 minutes or even less than 10 minutes to present the PMAC and the arbitration in particular. I decided to focus on 10 main questions, but then of course I will be happy to answer to any other questions. So what should companies care about these PMAC? Also, the president Zalar said it's not simply another arbitral institution. It's designed to complement the Unified Patent Court. And what I found particularly interesting is the competence of these arbitral tribunal within the PMAC. Basically, the PMAC can focus not only on European patents, not opted out, unitary patent, and SPC, which is the competence of the UPC, but also related disputes. And the definition in the arbitrational rules of the PMAC of related disputes means dispute involving also other patent application, other patent portfolio, other IP rights, provided that, and this is very interesting in my view, there is a factual, legal, or commercial nexus with an actual or contemplated dispute concerning a European patent, a European patent with unitary effect, or an SPC. So there should be this nexus, but in the end, the competence of the PMAC and of the arbitral tribunal is broader. And it will be interesting to see also how this nexus will be interpreted by the PMAC. Second question. Stop. Okay. When can parties submit a dispute to PMAC? I would say, short answer, they can start always proceedings before the PMAC. Before litigation, during litigation, after, and even independently of any judicial proceedings. If there is an arbitration agreement, and I share also the definition of this arbitration agreement, parties can also ask to start these proceedings unilaterally. Arbitration agreement is an arbitration clause or a separate contract where parties agree to devolve the case in case a dispute shall arise between these two parties, to the arbitrational tribunal and according to arbitration rules of the PMAC. So is this arbitration agreement indispensable and always necessary? No, is not. Basically, if there is an arbitration agreement, one of the party of this agreement can ask and can start the proceedings independently from the other side's consent. Whereas if this arbitration agreement is missing, an arbitration can start only when both parties agree to start. And so they make a joint request, or one party requests to start with the other party's consent. And of course, you need, in the request for arbitration, you need to show the reason that there is this arbitration agreement, or the other party's consent, or another legal basis, which for the time being, I don't know what is the clear reference to this legal basis, but in the future, probably there could be some regulation where they say for every dispute coming out from this topic, the competence will be solely of the arbitrational tribunal. Can PMAC decide patent validity? I find this topic very, very interesting, because in the UPC agreement, Article 35, paragraph 2 and 79, the UPC agreement expressly provides that the patent may not be revoked or limited in mediation arbitration proceedings. While we do know that rules of the 11 and 365 of the rules of procedure of the UPC clearly state that the UPC can confirm an arbitrational award where parties also undertake to revoke the patent, to limit the patent, or not to enforce a patent against the other party. So I asked myself, and I opened a ticket also with the PMAC. I did not receive an official answer, but still it is an answer. That is basically through the arbitration, you can obtain an inter partes effect. And even if the UPC then confirm such an award, this does not transform the effect from an inter partes effect to an erga omnes effect. So basically, it remains an inter partes effect. But still, within the arbitration proceedings, you can obtain between the parties an inter partes effect. So the answer is yes. Who controls the arbitration? Let me check the clock. The parties retain significant autonomy about the number of arbitrators, 1 or 3, the language of the proceeding, the seat of the arbitration, the applicable rules and the law, while the tribunal controls the timeline, can request evidence. There could be hearings also via video conference, and can also decide to record a settlement in the form of award if a settlement is reached within the arbitration proceedings. How does the PMAC arbitration proceed? What is the proceedings? There should be an initial request within 30 days, a response, and then it should be necessary to constitute a tribunal as a sole arbitrator with 3 arbitrators, and then the tribunal decide to set an initial case management conference as soon as practicable after the tribunal constitution. There could be some procedural order, the timeline, the request of other written submission, expert evidence, hearing, and then the final word, which should be issued within 1 year, more or less, as the UPC. What I found very interesting is the urgent relief. Can the PMAC and the arbitration tribunal issue urgent reliefs, injunction orders to preserve evidence? The answer is yes. And they can do both before the tribunal is constituted with a very interesting proceedings by appointing an emergency arbitrator who may grant interim or conservatory measures. Once the tribunal has been constituted, it may order interim or conservatory measures such as the preserve of the status quo, prevent imminent or irreparable harm, of course, to preserve relevant evidence, to protect confidential information, trade secrets, and so on. And of course, the PMAC can ask for a deposit of a security, and this does not exclude the recourse to the Unified Patent Court. Almost finished. How much does the PMAC arbitration cost? You need to pay a registration fee, which depends on the value of the proceedings. I already have 3,000, 6,000, or 8,000, depending on the value, up to 2 million, from 2 million to 10 million, and over 10 million. An administrative fee, also depending on the value. And then the tribunal's fees, which is a fee basically with an hourly fee from 350 to 750, and usually shall be capped by the tribunal at the beginning of the proceedings. There are some provision in the arbitration rules which basically parties can pay 50% of this fee, for example, for an expedited arbitration, or in case the proceedings come from a UPC, as you are probably all aware of. During the interim conference, the judge can push the parties to an arbitration solution. So in that case, the fees are reduced, but these are the cost. I won't say that it's cheaper than the UPC, but it is nice to see that is very predictable as well. Last question, why should parties choose the PMAC arbitration? I would say it's not because I am an arbitrator, but I would say it's very interesting because the expertise is very specific on patents and technology disputes. The competence is broader with respect to the UPC. The definition of related disputes I mentioned at the beginning is really interesting, and the interpretation of this nexus, in my view, will be very broad as well. The timeline and the case management could be very flexible, and the rules gives the tribunal such a power. Confidentiality has been named several times during the conference in Ljubljana, especially for the SIP proceedings, the standard essential patent proceedings, the possibility to enforce the award internationally due to the New York Convention, and of course to play a crucial role with the UPC litigation. Of course, it will be interesting to see if such an arbitration agreement will be widely included in the agreement, because basically I think that will be the first and most important path to reach the PMAC.